Welcome back, everyone. I hope you enjoyed your lunch break and had plenty of time to rack up points within Whova, comment in the community board, potentially meet up with people. I saw some people were trying to host some local meetups in your area, which is great. Our next speaker will have coming on here in just a second, but first I have just a few reminders and announcements as everyone starts coming in for the meeting. First off, I want to acknowledge one of our sponsors who didn't provide a video for us to show, but that sponsor is FMLA Benefit Solutions. And I'm sure all of you are familiar with FMLA. They provide our third-party administrative services, great team of people. They've supported us since we started working with them, and we just really appreciate their sponsorship and all of the time and effort that they put into making things work behind the scenes on the billing and eligibility side. Also, just a reminder to everyone that we are recording our meetings today, and so we will make those recordings available and notify you where you can find those recordings once we've got it all set up and ready to go. So please be aware that you will be able to view the sessions again after the meeting. Also, your bingo cards, keep working on those bingo cards. Again, for every bingo on your card, and it's one card per person, but for every bingo that you get, whether it's horizontal, vertical, diagonal, four corners, every bingo you'll get entered into a raffle for each bingo that you have. And then if you end up getting blackout bingo because you were very active in all of our sessions and all of our activities over the course of the summit, then you'll be entered into a second prize drawing for that blackout bingo. So again, if you need a copy of the bingo card, we sent it out via email. You can also access the bingo card in the document section, which is on the right-hand side of the Whova page, down in resources, leaderboard, sessions, video gallery, and then documents. So you can find another copy of the card in documents. With that, one other reminder about the leaderboard, we've noticed how active some of you have been within Whova, and every time you do an activity within Whova, it does generate more points. And so we will be awarding some prizes to the leaders on our leaderboard there, and you can see the leaderboard again under resources to see how you're doing. Also, you can go into the leaderboard and congratulate, just clicking on congratulate each of those leaders for all their activities within Whova. All right, with that, I would like to introduce our next speaker, Angela Hayes. Angela joined Associated Industries in January of 2009. She was previously a managing partner of Randall and Danskin PS. Her practice area included civil litigation, trust and estate dispute litigation, guardianship and medical negligence defense, as well as medical and negligence defense. Angela graduated summa cum laude from Gonzaga University School of Law and is also a registered nurse, offering a unique healthcare perspective to her work with members. Angela is licensed to practice law in both Washington and Idaho and is a member of the Washington State Society of Healthcare Attorneys, the American Health Lawyers Association, and the American Association of Nurse Attorneys. So with that, everyone, I hope you go join me in welcoming Angela to present on FMLA and PFML.
Well, thank you. Hopefully I'm technologically set up here. I'm loving the early text messages here saying go Zags, and I so wish that I could be wearing like a national champion, cap or something today. But what a fantastic season, and fun to have that here in the Inland Northwest and all the Zags that are on the line. So wonderful. Thank you for having me here today. I am thrilled to be here. I am going to be talking today. We're going to kind of revisit the paid family and medical leave program. And how that's what some of the updates have been and how that interacts with FMLA. And I know that there have been a number of questions that have already been coming in. I am trying to take control of my screen here so that I can advance the slides. There we go. So we're going to be talking about, again, paid family and medical leave here in the state of Washington, how that interacts with FMLA, and what some of the updates and some of the amendments have been since I was here talking to you, I think last year, about this very same topic, if I recall correctly. We've now lost my slides here. Not sure I tell you, best laid plans here as far as, I apologize. I'm not sure if you're seeing any slides on your screen, but I'm sure not on mine any longer. I don't know if there's somebody out there in technological land that can assist me because
You want to try pulling up the slides on your end again, sharing your screen again, now that we're on the Zoom platform?
All right, let's see.
Here,
Okay,
can you control it now, Angela?
I'll sure try. Okay, well, no good lawyer would start off any of these without some kind of disclaimer. So I'm just going to start off by saying that the information that I'm providing to you folks today is really for general informational purposes only, should not be construed as legal advice, does not establish an attorney-client relationship between myself and all of you folks out there who are attending, including my ZAG friends, and doesn't establish an attorney-client relationship between Associated Industries and anybody else attending the seminar today. When you have specific issues that arise, and particularly around these leave questions, which can be really challenging for employers, I would suggest that you attendees seek legal advice from obviously a licensed attorney, maybe one who specializes in employment law, if you're interested in joining Associated Industries, so you can have access to myself and other legal team members. We'd love to have you on board. The law in this particular area with respect to paid family and medical leave and some of the other changes that we're seeing really is changing pretty rapidly. And I don't have time necessarily to cover everything today. So what I'm presenting to you today is some general information, as up to date as I can get it. But I wouldn't be surprised necessarily if we see some other changes down the road with respect to paid family and medical leave as the state starts to work out some of the kinks that we're seeing. And I'm hearing that in the questions that have been posed here by folks today. Again, trying to get my slides to advance. There we go. Our agenda today, I'm going to do a quick review of paid family and medical leave basics, because it's going to bring us then to be able to talk about some of the recent amendments to paid family and medical leave. And when I say recent, these amendments took effect back about in June of 2020. So not quite a year ago, but they have been implemented since the last time I was here talking to you. So we're going to call those recent. I'm going to dive a little bit deeper then into talking about supplemental benefits, because I find that to be one of the areas that I work most with employers on and get a lot of questions about. It seems to be a very confusing topic for folks. I'm going to talk about continued health benefits. That was one of the areas that was subject to an amendment under the amendments that we're going to talk about. So again, when does an employee get continued health benefits while they're out on paid family and medical leave? And then I'll talk a little bit about, again, touching back on the intersection of paid family and medical leave and FMLA, because there's a lot of crossover and overlap and some issues that arise depending on what order an employee is taking leave on, whether those things can run concurrently or not. And then I'll do my very best to get to some of the really great questions that folks have been asking and have already been typing into the chat box. I unfortunately can't necessarily see the chat box as I'm doing this presentation. Somebody might be, Kimberly or somebody else might be reading me some questions at the end, but I'll do my very best to get to some of those. And the ones that I can't get to, I'll also do my best to maybe type up some answers that could be distributed to the folks that were attending today. So with that, we'll dive in with a quick review of some basics with respect to paid family and medical leave. And this is probably information that's known to everybody out there, but again, we're going to just do a little bit of a review here. As you all know, this is our statewide, essentially, insurance program that provides partial wage replacement to eligible employees under qualifying circumstances when they have to be out of the workplace due to family, medical issues, or military exigency needs. As you all know, the premiums for this, or the program, is being funded by premiums that are paid into the state fund by employees and most employers. Employers that have fewer than 50 employees are not actually required to pay any portion into the program, but the employee's benefits are not reduced if they work for a small employer. So even though an employee may work for somebody who has less than 50 employees, their benefits won't be diminished in any way just because their employer is not required to pay into the program. Premium collection started way back on January 1st of 2019, and benefits came online and came available to employees on January 1st of 2020. Reporting from the ESD and the folks that are processing those claims say that in the first month that benefits were available, ESD received as many applications for benefits as they were anticipating in the first 4 months of the program. So clearly it was a very popular program. I think ESD was really probably kind of overwhelmed with the response. and the processing that was going to be required with these claims. So we were seeing backups of claims of weeks and weeks and weeks. They seem to have gotten it down now to processing and approval time of about 2 to 3 weeks after a completed application is submitted for processing with complete documentation. So they've really been able to sharpen their processing times, but I know that was really a frustration for employees and employers early on in the program there. And I'll say Washington has been very progressive. I mean, we're one of only 5 states that has a program on board that is all fully functional and operational. There are a number of other states that are coming on board, but Washington was really one of the states that was at the forefront with these types of paid leave programs. So who's covered by Washington paid family and medical leave? It's essentially all Washington employers, including out-of-state employers that have Washington employees. They're all required to participate. That includes nonprofits, state and local governmental agencies, faith organizations, and other typically tax-exempt organizations or associations. Generally, all employees that are working in Washington will be paying premiums into the program, and they are covered by the program. Employees can't opt out of any part of the program. So for example, if an employee said, I'm not married, I don't have any kids, I don't want to have to pay into the family leave portion of the program, they can't opt out of any part of the program. They're paying into the program, completely for both any needs that they may have personally, or if they need to be out of the workplace to care for somebody else, or for military exigency needs and things of that nature. Folks or groups who would be exempt from the paid family and medical leave program would be self-employed individuals who are able to opt into the program if they choose to do that, federal employees, federally recognized tribes, which may opt in, and employees that are subject to an existing collective bargaining agreement that existed in October of 2017 until that collective bargaining agreement expires or is reopened or renegotiated. So we may see some, you may have some individuals who were subject to a collective bargaining agreement in the past. That collective bargaining agreement may have exempted those individuals from the program, so you wouldn't be reporting their hours, you wouldn't be collecting premiums from those individuals. But as that collective bargaining agreement comes up for renegotiation or is reopened or it expires, now those people will move into coverage of the paid family and medical leave program as that collective bargaining agreement is again reopened, renegotiated, or the old one has expired. They may be entering into a new collective bargaining agreement, and now those people will be part of the paid family and medical leave program. An eligible employee would be any employee who has worked for at least 820 hours for any employer or a combination of Washington employers during the qualifying period. And the qualifying period that the state would be looking at is the first 4 of the last 5 completed calendar quarters, or the last 4 quarters from the date that the leave is to begin. So that 820 hour threshold could be hours worked from one employer. It could be somebody who has a number of different jobs. All of those employers are reporting that individual's hours to the state, and collectively all those hours could bring that person to the 820 hour threshold. An eligible employee would be able to take paid family and medical leave for any of the following qualifying reasons. That would be bonding leave. So that would be time off to spend with a child who arrives in the household, birth, adoption, foster care. That type of leave has to be used within the 12 months following birth or placement of a child within the household. An employee may need time off of work and may be eligible to take paid family and medical leave to care for a family member's serious health condition. It may be that the employee needs time off of work for a qualifying exigency rising out of a family member being on active duty in the military, or having been notified of an impending call or order to active duty. Or probably most likely what you're seeing is that you have an employee that needs to be out of the workplace to care for their own serious health condition. Now, the amount of leave that an employee would be eligible for is going to depend on why they need to be out of the workplace. So an employee could be eligible to take anywhere between 12 and 18 weeks of paid family and medical leave under these different circumstances. So somebody would be eligible for 12 weeks of leave to care for a serious health condition of a family member. They might be eligible to take 12 weeks of leave for military exigency needs. They could take 12 weeks of leave for bonding leave, or 12 weeks for the employee's own serious health condition, plus an additional 2 weeks for a total of 14 weeks if the employee is disabled as a result of pregnancy. So for their own serious health condition, if you are a woman that has a disabling condition as a result of pregnancy, you would actually be entitled to up to 14 weeks of leave. Now, an employee would be entitled to a total of 16 weeks during a claim year for any combination of the above. So it's not 12 weeks for each of these things. It would be a total of 16 weeks combined for any of those conditions listed above, with that additional 2 weeks for a total of 18 weeks if the employee is disabled as a result of pregnancy. Now, the amount of paid family and medical leave that would be available to an employee under the state program will not be impacted by or set off or decreased by other leave that the employee may have taken even for that same condition, such as FMLA leave, for example. So if an employee had been out of the workplace on FMLA leave and they had not applied for paid family and medical leave benefits, and say they had taken 12 weeks of FMLA leave for their own serious health condition, for example, and the employee wasn't ready to return to work. So the employee decided they would go to the state and apply for paid family and medical leave benefits, that same condition that the employee had that they'd just been on FMLA leave for. The state will not take into consideration that the employee has just been off of work for 12 weeks under FMLA when they're deciding whether or not to grant benefits for the employee for that condition. Don't know why my slides switched there, sorry. Let's see, I need to go back here for a minute. Prior leave may affect the number of hours that an employee has worked with respect to meeting that 820-hour threshold for eligibility. But again, the state will not diminish or decrease the amount of time the employee has available under paid family and medical leave just because the employee may have taken other leave prior to that even for the same condition. Now, the amount of benefits that an employee will be entitled to while they're on leave will be calculated based on the employee's wages. There is a minimum weekly benefit of $100 and a maximum weekly benefit of $1,000. Now, paid family and medical leave benefits may be offset by other wages that the employee receives during the week. If an employee reports the receipt of an employer-provided benefit like sick leave or PTO that they may be using to top off a paid family and medical leave benefit, the state will view that employer-provided benefit as a wage, and they will commensurately decrease the employee's weekly paid family and medical leave benefit accordingly. So that's where it becomes really important when we're talking about supplemental benefits, that the employees understand and that the employers understand that when you designate something as a supplemental benefit, like you're going to allow your employees to use sick leave or PTO or vacation leave to supplement any benefit that they receive from the state, that everybody understands, the employee understands, and the employer understands that those benefits or that wage that's provided to the employee is not going to be reported to the state as wages earned by the employee during that benefit week. Instead, we're going to consider it supplemental, and it doesn't get reported to the state, and therefore the employee's paid benefit from the state will not be reduced commensurately. And I'm going to dive into that a little more deeply when we get to the topic of supplemental benefits. But I have had a lot of employers come back to me and say, you know, the employee used the benefit calculator, and I've provided the link there so that you can see, an employee can tap into that link and see how much benefit they might expect to receive while they're out on leave. And the employer comes back and says, you know, they were anticipating that they were going to receive, say, $1,000 a week, the maximum benefit, and they ended up receiving much less than that. Why was that? And I would often ask the employer, well, did you allow the employee to top off those benefits by using something that the employer provided, like PTO or sick leave or vacation leave? And the answer to that often was, yes, we did allow them to top off. And my thought was, you know, the employee probably then was reporting that to the state as wages received from the employer. And the state would just look at that as, again, wages received from the employer and decrease that employee's benefit commensurately. So when we talk about supplemental benefits, it's really important that you train your employees to understand what supplemental benefits mean and understand how to treat those when you are receiving paid family and medical leave benefits from the state. Now we're going to dive, so with those basics in mind, we're going to dive into some of the paid family and medical leave amendments that took effect in June of 2020. So there was some definitional changes with respect to paid family and medical leave. One of those was casual labor. That's now being defined as work that is performed infrequently, 12 or fewer times per calendar quarter, and irregularly. So casual labor is not considered covered employment for purposes of Washington paid family and medical leave eligibility. And the employer need not report those hours or remit premiums for casual labor. So if you have somebody engaged in casual labor, again, as defined, that's something that is performed infrequently and irregularly, those will not be subject to reporting. They will not be subject, or the wages earned through casual labor will not be subject to premium deductions. The definition of child under family member, and remember, family member is quite broadly defined under our paid family and medical leave program. Family member, child under family member is the definition has been expanded to include the child's spouse. So that means a son-in-law or a daughter-in-law of an employee. Supplemental benefit payments have been specifically defined now as payments made by an employer to an employee as salary continuation or as paid time off, and paid by employers in addition to any paid family and medical leave benefits the employee receives. And again, I think it's worth spending some time really diving into supplemental benefits because it has really raised a lot of questions. Paid time off is now defined to include vacation leave, personal leave, medical leave, sick leave, compensatory leave, or any other paid leave benefit that is offered by an employer under an employer's established policy. The amendments clarified that the state will not prorate or reduce an employee's paid family and medical leave benefits when they receive supplemental benefit payments from the employer. And again, this is going to dive into that supplemental benefit discussion a little more deeply. There were changes to the waiting period requirement. As you'll recall, there's a 7-day waiting period requirement to receive benefits under some of the eligibility criteria. There is no 7-day waiting period for bonding leave, and the statute has now been amended to eliminate the 7-day waiting period for qualifying military exigency leaves. If the employer needs to be out of the workplace for their own serious health condition or to assist a family member with a serious health condition, the 7-day waiting period before benefits will kick in still applies. It also clarified that the waiting period will begin on the previous Sunday of the week that the employee takes leave for the minimum claim duration of 8 hours. So they were kind of clarifying when does the waiting period begin? And it also clarifies, I think very importantly, that employees can satisfy that 7-day waiting period even while they're receiving paid time off benefits from the employer. So during that 7-day waiting period, if the employee wants to tap into an employer provided benefit while they're waiting for their state benefits to kick in and they're waiting to satisfy that waiting period, the 7-day waiting period imposed by the statute and by the WAC, the employee can tap into, if the employer allows, to their PTO benefits, and that will not jeopardize or in any way, affect the waiting period that the employee is having to work through. The amendments also clarified that an employee is disqualified from receiving any paid family and medical leave benefits in any week in which the employee is receiving or will receive or has received unemployment, Washington permanent disability, Washington temporary disability, or any other applicable federal unemployment benefits, industrial insurance, or disability insurance law type benefits. So there will be no double dipping into some kind of government provided benefit to the employees. Again, doesn't mean that you can't allow your employees to utilize supplemental benefits while they're receiving paid family and medical leave benefits, but any of these benefits that are listed here that are governmental type programs would eliminate the employee's ability to also get paid family and medical leave benefits during that same time period. The amendments also expanded the scope of complaints and investigations. So it outlines the complaint procedure now for employees if they believe that the employer is interfering with their ability to take paid family and medical leave. It outlines the department's authority to investigate claims or allegations maybe by employees about interference and things of that nature. It also provides a private right of action for an employee to bring a private lawsuit to sue an employer for violations of paid family and medical leave benefits, which I think is probably one of the most important things for employers to understand, that it is not just now that an employee could go to the state and file a complaint. It's that if the employee believes that their ability to take paid family and medical leave has somehow been interfered with by the employer, there is now a private right, or an employee could bring a private lawsuit or private right of action with respect to that interference claim. Just waiting for my slides to advance here. Okay. There was also a change or a modification made to those conditional premium waivers. And that was those circumstances in which an employer might have had an employee who at the time didn't live in the state of Washington, only performed some work in the state of Washington, and the employer was wondering, can we somehow waive the premiums for those individuals? So the requirements in order to obtain a premium waiver have been modified. Previously, the employee had to be physically based outside of the state of Washington to be considered for a premium waiver, meaning they lived somewhere outside of the state of Washington and they were only in Washington occasionally performing work on behalf of maybe the Washington-based employer. So the statute and the administrative rule now provide that the employee primarily performs work outside of Washington and is not expected to perform 820 hours of work in the state of Washington during a claim year period or during those 4 quarters preceding the need for leave, for example. So the requirement that the employee actually be physically based outside of the state of Washington has gone away. You could seek a temporary or a conditional premium waiver if you have an employee that is only that is primarily performing their work outside of the state of Washington and is not expected to perform 820 hours of work in the state of Washington during that 1-year period. Now, if you are going to seek a conditional premium waiver from the state, and I've included the link there where you can learn more about or find the form to actually apply for a waiver, the employer still has to report the employee's hours worked. And once the employee, or if the employee works more than 820 hours in 4 consecutive quarters, the waiver will expire and the employer and the employee will then become responsible for paying all the premiums that would have been collected on the employee's behalf during the 4 quarters in which they worked those 820 hours. So just the employer needs to remember, you need to continue to report the employee's hours to the state, just as you would with any of your other employees. And that if the employee actually exceeds the 820 hour threshold, the employee and employer, if they are of the appropriate size, are going to be liable then for all the premium payments that should have been made during that 820 hour time period where they were subject to that conditional premium waiver. And then the employee would be eligible to utilize those benefits. Okay. So I think we're going to jump into now talking about supplemental benefits. And as I mentioned, this is an area where I get a lot of questions from employers. They don't really understand what supplemental benefits are. How do we designate them? Do we need to contact the state to say that we're designating something as a supplemental benefit? So I like to dive into this a little bit more deeply so that employers and employees have a clear understanding really of what supplemental benefits are. And then I want to talk to you a little bit about why might it be important for an employer to allow employees to utilize supplemental benefits? And it ties in really nicely with a question that I got before this program started, was about what do we do with employees when we have this program has been very popular. We've ended up with a lot of employees taking leave at the same time. Is there anything that we can do to address that or control that, or how do we work within the parameters of paid family and medical leave when we've got all these people taking leave? I think there's very little that you can do as the employer if that happens, because they have if the employee is eligible for it, they have an absolute right to take it, and you don't want to interfere with their ability to do that, because again, remember I just mentioned that they now have a private right of action, and you don't want to get caught up in that. But supplemental benefits might play a part in sort of, kind of putting some guardrails on how much leave an employee has to take. So let's talk about that and how you might utilize supplemental benefits to your advantage as the employer. So again, supplemental benefits are defined as a payment that is offered by the employer to an employee who is taking leave under the paid family and medical leave program. Now, the employer can choose to designate any or all of their employer provided benefits as supplemental benefits that the employee could use to supplement their paid family and medical leave benefits that they're receiving from the state. So for example, say the employer offers a PTO program or a vacation program or salary continuation programs, or maybe, paid family, their own paid family leave program, Washington state paid sick leave benefits, for example, any of those employer provided benefits, an employer can decide we are going to allow our employees to use those as supplemental benefits when they are receiving paid family leave medical benefits from the state. So the employer has the ability at the outset to designate which of those employer provided benefits they want to allow their employees to use as supplemental benefits. And a great question just came in. If you offer supplemental benefits, do you need to treat those the same for each employee? And I would say the answer to that is yes, because you don't want to be appearing to act in any kind of discriminatory manner. So if you're going to allow employees to, if you're going to designate something as a supplemental benefit, you should allow all of your employees who are eligible for that benefit to use it in this supplemental fashion that I'm describing here. So the employer can also designate how much of a supplemental benefit an employee may use. So say the employer is going to designate, allow employees to use any of the employer provided benefits to supplement their paid family and leave medical benefits, paid family and medical leave benefits that they receive from the state. So we as the employer say, we have a policy that says we're going to allow our employees to utilize their vacation leave, their PTO leave, their personal holidays, any other paid leave that they may have available to them. We will allow them to use those as supplemental benefits when they are receiving paid family and leave medical PFML benefits from the state. Now, the employer could allow the employee to use that benefit, the supplemental benefit, at 100%, meaning the employee would receive some type of percentage of their wage from the state through paid family and medical leave. And then the employer could decide, we don't want to have to go through the accounting of just trying to top up to 100%, make the employee whole. We're going to allow the employee to utilize their supplemental benefit, their vacation leave, their PTO or whatever at 100%, which would mean that the employee is receiving more wages than they would if they actually were at work. That's up to the employer. The employer has the prerogative to allow the employees to do that. The state doesn't care. So if the employer wants to allow employees to top off their paid family and medical leave benefits, by fully using their supplemental benefits, the employer can do that. The employer could also say, we will allow employees to utilize their supplemental benefits to bring them whole, to make them whole, or to top up to 100%. And that the employer has the prerogative, you have the right to do that. And that would bring the employee to 100% of their regular benefits. That would require the employer and the employee to work together to find out how much the employee received from the state. And then the employer would, pay the employee, the remainder from their, supplemental benefits to make them whole. I have worked with employers that find that to be very burdensome. Sometimes the employee's payments, from the state are, kind of lagging behind. So many of the employers that I've worked with have just said, you know what, we're just going to allow the employee to use their benefit as a supplemental benefit to the fullest extent. And we're not going to try and just make them whole. They can utilize the full benefit if they want that, if they want to do that. One of the benefits of doing that, and so then another great question, does the employee have to use accrued leave or can they elect just to receive state benefits? The answer to that is the employee if the employer is going to designate something as a supplemental benefit, the employee then has the right to either use it or not. You can't force the employee to utilize the supplemental benefit. You can only make it available to the employee. Now, so again, to start off, the employer may offer supplemental benefits, may designate any of the employer provided benefits as supplemental benefits. You are not required as an employer to do that. But my encouragement would be, again, for that reason that I just mentioned earlier, that came from that great question, how do we somehow control all this leave that employees are taking? If you allow employees to utilize their things like vacation and PTO, personal holidays, as supplemental benefits when they're receiving paid family and medical leave benefits from the state, that starts to skinny down the other types of leave that they will have available to use at a later time, like their vacation leave or their sick leave or something of that nature. So we offer it to them and they utilize it. The employee is benefiting because they're being made whole, or maybe even more so. And the employer then is, having some guardrails on how much leave then employees are going to have available to them, as time goes on, because they may choose to use those supplemental benefits during their period of leave, and then, they won't have it to use later on. If the employee, and I have another question here, these are kind of popping up as I'm going through the presentation. Oh, I missed that one. I'll come back to that question. So again, employers are not required to offer supplemental benefits at all, but I would encourage employers to do that, again, because it controls the amount of leave then that employees may have available to them later on. There is no magic requirement to designating something as a supplemental benefit, so you don't need to alert the state that, hey, we're going to designate our PTO or vacation plan or personal holidays as supplemental benefits. You would do that internally. And I would recommend as a best practice for employers that you identify in your policies or in your handbooks which benefits, if any, you are going to allow employees to use as supplemental benefits. That way everybody is on notice, and there's that consistency piece that, you know, all employees then will be allowed to utilize those benefits as supplemental benefits. If the employer offers supplemental benefits, then this gets to that next great question that was raised. The employee then has the option whether or not to use them. You can't force the employee to utilize a supplemental benefit. You can only make it available to them if you choose to do that. The supplemental benefit will not reduce the amount of the benefit the employee receives from the state. So this is an important piece of education for your employees if they are going out on leave. My recommendation would be, if you are going to designate something as a supplemental benefit, I would, one, identify that in your handbook that we are going to allow employees to utilize their vacation leave or their PTO or their personal holidays or any or all of them as supplemental benefits when they are receiving paid family and medical leave benefits from the state. It's at the employee's option to do that. When the employee takes leave, I would have the employee identify to the employer, one, does the employee want to use supplemental benefits while they're out on leave? So you have it in writing that they either wanted to use them or they didn't. If they do want to use supplemental benefits, have the employee designate which benefits they want to use. I want to draw down my vacation and utilize that supplemental benefit while I'm on leave, for example. The third thing that I would say that you want to educate your employee on before they take that leave. Now they've said, yes, I want to use supplemental benefits. I want to use, you know, any and all benefits available to me, or they've specified which benefit they want to use while they're out and receiving paid family and medical leave benefits. Make sure that the employee understands supplemental benefit payments are excluded from the definition of wages. So when the employee is filling out their weekly claim form with the state, they do not report those supplemental benefits as wages received from the employer. If they do that, the state will just view those as wages, and they will draw down or decrease the amount of benefit that the employee receives. So that there are no surprises. You want to make sure your employees understand, you have asked to use this as a supplemental benefit. We will permit that because we have a policy that says we're going to allow employees to use these as supplemental benefits. When you file your weekly claim forms, do not report these supplemental benefits as wages received from the employer because they are outside the scope of wages by definition. Likewise, the employer does not report those supplemental benefit payments to the state as hours worked or wages earned by the employee, and you don't take any premium payments out of those. So when you are designating something and allowing an employee to use something as a supplemental benefit, it falls totally outside the scope of what you would report to the state. It falls outside the scope of premium collection, and it falls outside the area of wages. So the employee likewise does not report those to the state. So hopefully that's clear. And I think that's a really good piece of education to do with your employees when they are taking leave. And I've had some employers, you know, put together a form, for example, when the employee has notified the employer that they're going to take paid family and medical leave benefits, that they put together a form that explains, if you're going to utilize supplemental benefits, explains what the supplemental benefits are, has the employee again on this form, just, and I'm using, you know, this is not required. This is just sort of a best practice so that everybody's on the same page about how this is going to work. Have the employee designate, yes, I want to use supplemental benefits, or no, I don't, and designate which benefits they want to report that they want to utilize as supplemental benefits. And then again, maybe a little educational piece there that says to the employee, do not report your supplemental benefit payments to the state on your weekly claims. Otherwise, your benefits from the state will be reduced. So those fall outside of the state definition of wages. And yes, there was a message that popped up there that said, this is a tax and accounting nightmare. And I do not disagree with that at all. It totally is, because I don't know anything about accounting, but I do know from the folks that I've talked to in payroll departments, it's like, this is really difficult to designate because you run into the situation then where you have a benefit that on one hand, so for example, wages, sick leave or vacation leave or personal holidays, when they're being used in the fashion for which they are intended, like somebody is taking vacation or somebody is taking a sick day, not related to paid family and medical leave, or somebody is utilizing a personal holiday, those get reported by the employer to the state as wages paid and hours worked. And you take premium payments out of those, just as you would somebody's regular income when they are being used for that purpose. But when you take them out of that category and you designate them as supplemental benefits, it's the same benefit, you're just designating it as supplemental, and it takes it out of the definition of wages as far as the state is concerned. And then you treat it differently. You don't take the premium payments out of it. You don't report it as wages earned. You don't report it as hours worked. So yes, it is an accounting nightmare for all those folks, that are having to deal with that. Another great question: was there a sample template, paid family and medical leave form for employers that are doing that? I don't have one at my fingertips, but I could certainly try and find something that might be generated or circulated around among the folks here that were attending today. Okay, so again, remember, with respect to supplemental benefits, no, they could not have made this more confusing. Somebody just asked. They could not have. Yes, it is very confusing, which is why I really wanted to spend some time talking about it today. And I hope that it's become a little bit more clear about really what supplemental benefits mean. So again, remember, the rules specify that supplemental benefit payments are excluded from the definition of wages. So when somebody is using a benefit in a supplemental fashion, they're not reported to the ESD. You don't report them as the employer as hours worked or wages paid. The employee does not report them on their weekly claim form as wages paid, and they are just treated in that supplemental fashion. So again, there's some best practices listed there, the ones that we've just talked about how to address supplemental benefits within your workplace. Designate it in your policy or your handbook. Clarify that some benefits may be able to be used in a supplemental fashion. Again, I would encourage employers to allow employees to do that. Even though the tax and the accounting nightmare is frustrating, again, it starts to limit the amount of leave that an employee might have, because if you don't allow employees to use supplemental benefits, that means they're just using their paid family and medical leave benefits, those wages, and then they still have this whole pot of employer-provided leave out there that's untouched that they can use at a later time. And then you have, again, maybe the leave is just continuing to be extended and extended because they haven't tapped in to that employer-provided benefit. So if you allow somebody to use it in a supplemental fashion, they may be more inclined to use that benefit, and then it leaves less in the pot for later on, when employees are, perhaps extending their leave. And then again, the discussion that you want to have with your employee before they take leave, ask them if they want to utilize supplemental benefits, have them designate yes or no that they do or they don't, and make sure that they understand that if they are using supplemental benefits, they don't report that to the state in those weekly claims. Now, I do want to talk a little bit about supplemental benefits though, and FMLA. As I mentioned, if somebody is on paid family and medical leave, you can offer supplemental benefits, but you can't require the employee to use it. Now, that's a little different with FMLA, because under FMLA, those federal regulations say that an employer may actually require the use of all paid leave before the FMLA leave will become unpaid. So it's different in the federal world where somebody is just on FMLA leave. So if you have an employee who is on FMLA leave and they are not on Washington paid family and medical leave, you can actually enforce a policy that says that you are required to use all available paid leave before your FMLA leave will become unpaid. Now, there is a caveat to that in the state of Washington. Statutorily protected sick leave, now that it is a benefit that is mandated by the state, an employer cannot force an employee to use paid sick leave. You can't force an employee to use paid sick leave when they're on FMLA. You may have a policy that says you have to use all paid leave benefits before your FMLA leave will become unpaid. There needs to be a little asterisk next to that now, because You can't force somebody to use their Washington state paid sick leave. You can force somebody to use their PTO or their vacation leave or their personal holidays or whatever other type of paid leave benefit that they might have available, but you can't force them to use paid sick leave. Underpaid family and medical leave, however, as I just mentioned, required use is not permitted. So again, they have the option. If the employer is going to allow supplemental benefits, the employee then has the option to use them or not. That's different, again, under FMLA, where you can force it, except for Washington state paid sick leave. Now, there may be instances in which the employee is taking FMLA and paid family and medical leave concurrently, and we're going to talk about that in just a minute. The rules and the statutes don't offer any clear guidance on this conflict, but my recommendation to you would be follow the law or the rule that would provide the most protection to the employee. So if you have a situation where the employee is out on paid family and medical leave through the state, and you're also running FMLA concurrently, I would follow the state rule that says you can permit an employee to use an employer provided benefit, but I would say your FMLA policy probably needs to take a back seat to that. And you wouldn't force an employee to use their paid leave benefits before the leave would become unpaid. I know that starts to get a little bit confusing, and I'm going to talk here at the end a little bit about, and there was another good question here that is correct, that in Washington state, you can't require an employee to use sick leave of any kind during FMLA. That is correct. The Washington state paid sick leave statute, where the employee is earning 1 hour for every 40 hours worked for your non-exempt employees, you can't force those employees to utilize their paid sick leave while they're out on FMLA leave, even though you may have a policy that says you must use all of your paid leave benefits before the leave can become unpaid. You can do that with respect to like vacation leave or personal holidays that are not mandated by the state. That's strictly an employer provided benefit. But sick leave, since it is mandated by the state and it is now a state governed benefit, you cannot force an employee to utilize sick leave while they're out on FMLA. When you say, then there was another question that said, well, what about just normal sick leave to full-time employees? If you're talking about the sick leave that you are providing to regular full-time employees through the state program, then that rule applies. You cannot force an employee to utilize those sick leave benefits while they're out on FMLA. No, there are so many great questions here, but I am trying to get through this information. Short-term disability benefits are treated a little bit differently by the state. So STD benefits are not considered a supplemental benefit under the WAC. They're carved out even a little bit differently. They're also not considered reportable wages. So per the Employment Security Department, the state will consider STD benefits as a different carve out altogether that is controlled by the employer and controlled by the terms of the short-term disability plan. And therefore the state will not reduce an employee's paid family and medical leave benefits if they are also receiving STD benefits. Now, the plan itself may control that. The plan itself may say, determine if and when the employee can tap into STD benefits if they're also receiving benefits from the state, but that'll be controlled by the terms of the plan, not by the state. So again, per the terms of your STD plan, disability benefits that the employee receives through short-term disability may be offset by some amounts that the employee receives from paid family and medical leave. That will just all be controlled by the terms of the plan. But likewise, just like supplemental benefits where you don't report those as wages and you don't take premium payments out of it, the same goes for short-term disability benefits if the employee is tapping into that benefit while they're getting paid family and medical leave benefits as well. Now, there may be times, again, when the employee is eligible for paid family and medical leave, like, for example, for the employee's own serious health condition, maybe due to COVID-19 or to care for the serious health condition of a family member. And the employee may be able to tap into those optional emergency paid leave benefits under the FFCRA. So now we're adding kind of a new layer of complication to this. So for example, if you are an employer that is now optionally offering FFCRA benefits to your employees, and you're taking that tax credit, that federal tax credit for providing those benefits to an employee. The employee may be out of the workplace and eligible for those optional FFCRA benefits for a reason that would also qualify them for paid leave benefits through, the paid family and medical leave program. FFCRA benefits are another category of benefit that can be designated by the employer as a supplemental benefit when they are being used in conjunction with paid family and medical leave. Now, I haven't heard any different because, of the tax credit situation. So my understanding is that those FFCRA benefits, if you are an employer that is offering those to employees, that there may be a situation in which an employee could be out of the workplace for a reason that would qualify them for both FFCRA benefits because maybe they are ill with COVID-19, which would also be a serious health condition under paid family and medical leave. So the employee may be eligible for benefits there. You would treat those FFCRA benefits the same as you would any other supplemental benefit if you choose to do that and if you choose to offer those. Again, those benefits are optional, and the FFCRA benefits are optional at this point. So there are many employers that are just not wanting to deal with that at all, or you don't have to designate that as a supplemental benefit if you just don't want to, deal with those temporary benefits. So I'm going to talk quickly about job restoration and continuation of health benefits and these few minutes that I have left. Remember, under paid family and medical leave, there are situations in which an employee would be entitled to be restored to the same or an equivalent position that they held when their paid family and PFMLA leave started. And those are under the circumstances where you have an employee that works for an employer that has 50 or more employees, and they have worked for that employer for at least 12 months, and they have worked at least 1,250 hours in the last 12 months preceding the need for leave. The employee does not meet those criteria. Maybe they don't work for an employer that is large enough to be subject to job restoration requirements. Or maybe they haven't worked for the employer long enough, or they haven't worked enough hours to be eligible for job restoration. It doesn't mean that the employee isn't entitled to take paid family and medical leave. It just means that they aren't entitled to job restoration. So I wouldn't say to an employee, because you don't want to give the appearance of interfering with their rights of taking paid family and medical leave. They'd still probably be eligible for paid family and medical leave benefits. It just means that they may not be eligible for those mandatory job restoration benefits. And what the employer's response to the employee would be, we understand that you're taking paid leave. We just want you to understand that because of these criteria, because we're less than 50 employees, or because you haven't worked for us for long enough, or you haven't worked 1,250 hours in the last 12 months, you may not be entitled to be restored to the same position that you held at the time your leave commenced. You don't say to the employee, you're not entitled to leave. That's a decision for the state to make. It just means that you may not have to bring the employee back to the position that they held when the leave commenced. Now, there are some, employers may try and hold the job open for the employee, or they would entertain bringing the employee back to work at the conclusion of the leave. But again, it doesn't mean that the employee is not entitled to leave. It just means that the employee isn't entitled to be restored to the same job or an equivalent position that they held at the time that leave commenced. Now, continuation of health benefits is really kind of a tricky one because it totally depends on whether the employee is also taking FMLA leave concurrently, or at least that there's an overlap. So in the amendments, it was clarified that an employee is entitled to continued health benefits for the duration of their paid family and medical leave if it is required by the Federal Family and Medical Leave Act. So what that means is that the employee will be entitled to continuation of health benefits for the duration of their paid family and medical leave, as long as they have been on FMLA and there's at least 1 day of overlap between their FMLA leave and their paid family and medical leave. There has to be at least 1 day of overlap, concurrent use between FMLA leave and paid family and medical leave for those benefits to continue then through the duration of their paid family and medical leave. So the key to this is that FMLA and paid family and medical leave must overlap by at least 1 day for the employee's health benefits to continue for the duration of paid family and medical leave. Now, the employers can require the employees to continue to pay their portion of the health benefit premium, just like you do under FMLA. But the key to this is there is no independent right to continued health benefits under the state program. The continuation of health benefits for an employee for the duration of their paid family and medical leave benefit is totally dependent on FMLA. So that means that the employee has to have been on FMLA leave, and that the FMLA leave is overlapping with their application to the state and getting those paid family and medical leave benefits, and it's overlapping by at least 1 day. So again, there is no independent, so if the employee only takes Washington state paid family and medical leave, there is no independent right to continued health insurance benefits for that leave. They have to have at least taken FMLA leave, and that FMLA leave has overlapped with their Washington state paid family and medical leave benefits by at least 1 day. So that's really important, I think, for employers to understand and employees to understand that they, and here's a great question. If they take paid family and medical leave before FMLA, you are not required to continue their benefits, because at the outset of the leave, the employee takes Washington state paid family and medical leave. Here's what, and here's where we get to this, the intersection of paid family and medical leave. And I know I'm running over here by a minute or so, but I think this is important to understand. There may be situations in which the employee would be qualified for both Washington state paid family and medical leave and FMLA at the same time. So for example, the employee has their own serious health condition, or they're caring for a family member with a serious health condition, and the family member is a parent, child, or spouse that's also recognized under FMLA, or the employee is taking leave for bonding leave, which is also recognized under FMLA. The employee, if they take Washington paid family and medical leave first, they go to the state, they apply, they give the employer notice that they're taking leave for their own serious health condition, for example, and they say, I'm going to go to the state and apply for paid family and medical leave benefits. That, I think, is the signal for an FMLA employer to start the FMLA paperwork with the employee if it's appropriate to do so. Because the state statute says if the employee is taking paid family and medical leave for a reason that would also qualify for FMLA, they shall run concurrently. So the employer can run those two concurrently. If, however, and as many employees have become wise to this, they only come to the employer and request FMLA leave first, the employer can't force the employee to go to the state and also apply for Washington state paid family and medical leave benefits. And so there is the potential for the employer to use, the employee, to use FMLA first, followed then by Washington state paid family and medical leave. And you can see then those are running end to end, because the employer can't force the employee to apply for state paid benefits first. But if the employee applies for state paid benefits first, then the employer can run FMLA concurrently right on top of that if it is also an FMLA qualifying reason. I think that I'm out of time here. I see Kimberly pop up. You guys have had great questions. I'll do my best to answer some of these if I can find the time, and if I can pull these up off the chat to provide some more information for all of you, because you were asking some really great questions. And yes, the slides, I'm happy to share the slides. I'm hoping that they can be made available through the Whova page.
Yes, we will get the slides up for everyone so that you can download them and then also have them available. We're not quite sure what format yet, but we will let everyone know once we've got all the materials posted and available to you.
And my email address is there. If you want to send me an email, I'll do my best to get back to you with some responses to your questions if I didn't get to them today, or if you aren't finding the information in the slide. But thanks very much. This is a challenging topic, and I'm glad that I was able to come back and talk to you about it again.
Yeah, Angie, thank you so much again. There was a lot of really good information, a lot of updated information. We really appreciate your time so much. And thank you again for joining us.
Yes, have a great rest of your conference.
All right.
Thanks
okay, everyone, we are going to go and have a quick break. Our next meeting will start at 2:30 p.m. Feel free, if you do have questions in the Q&A box in Whova for Angie, you can go ahead and post them there. We will make sure she gets those forwarded to her, and then we will forward her responses out once we know what format that will be in. So thanks everyone for attending, and we will see you in the next session.